This video is for informational purposes only and is not intended to be legal advice.
Hello there, I'm Joseph Lavelle. I'm an Oregon attorney. I am the founder of Dynamic Legal Solutions LLC and also the principal attorney of Navigate Legal Services LLC. I'm here to discuss an article I wrote called Is It Better If I File for Divorce First in Oregon? Filing first, for the most part, will not give you any advantages in a divorce proceeding. There are, however, instances when it may be beneficial to start a divorce proceeding versus waiting. Generally speaking, the spouse who files first is known as the petitioner in the divorce proceedings, and the other spouse is known as the respondent. The document the petitioner uses to file first is called the petition. The petition is the document where you tell the court historical background information about the parties and children and also what you want the court to grant for you, such as dissolving the marriage, custody, and property distribution. The petitioner files the petition with the court and then serves the respondent a copy of the petition. Once the respondent is legally served, he or she has 30 days to file a response with the court, or else the petitioner can request for a default order in divorce judgment without the respondent's participation. If the respondent files a response timely, then the case goes through the court process. The response tells the petitioner and court what the respondent disagrees with from the petitioner's petition. Also, like the petition, the respondent's response can make counterclaims, which are requests that they would like the court to grant for them, such as how custody and property distribution should be awarded. Thus, both parties have the opportunity to inform the court what they want to be awarded. The court will weigh the issues of how to award the request from the parties based on other considerations and not the sequence of who filed. So when does filing first matter? Filing first matters for where the case will be heard. If you and the other spouse live in different counties or states, filing first could establish the divorce proceedings in your county or state because the first person to file does so in the county in which they reside. Obviously, it would be more convenient to have the case heard in the county in which you reside rather than to have to travel or find assistance in another county or state. I said that this could establish the divorce proceedings in your county because, in Oregon, a party could request the court to change venue, meaning the proceedings are moved to a different county. The main argument to change venue would be that the other location is a more convenient forum, meaning that it makes more sense to have the case heard there because the proximity of other witnesses, the children, and other considerations. Another area there could be benefits is with regard to child custody and parenting time. This is the case with status quo orders, which seeks to maintain the child's usual place of residence and schedule. So, for example, say the parties typically shared parenting time between each other and the child. Then, for whatever reason, say one parent had the child exclusively for 3 months. The parent who has had the child exclusively would have an advantage for child custody and parenting time purposes if they initiated a case after the 3 months of having the child exclusively versus what was previously occurring of shared time if the parent files what is known as a status quo order, which prevents either parent from 1. Changing the child's usual place of residence, 2. Interfering with the present placement and daily schedule of the child, 3. Hiding or secreting the child from the other parent, 4. Interfering with the other parent's usual contact and parenting time with the child, 5. Leaving the state with the child without written permission of the other parent or the permission of the court, or 6. In any manner disturbing the current schedule and daily routine of the child until the motion or modification has been granted or denied. This occurs because the court looks back at the last 90 days to determine what is the status quo of the child and, in the interest of continuity and consistency for the child, wants to keep that in place. Bad acts or conduct from a parent can also have an impact on custody and parenting time outcomes. In determining custody, the court considers the conduct of the parties only if it is shown that it causes or may cause emotional or physical damage to the child. For example, say the parent recently got arrested for some bad act versus doing the same act 10 years ago before the parties had children together. The more recent incident is going to hold much more weight with the court than the act 10 years ago, even though it was the same act. If too much time passes from when the bad act occurs and when filing occurs, the bad act's impact on the case may get reduced or shown that it does not have any negative effect on the children. So the bottom line here, the court does not give preference to the petitioner for the sole reason that they started the case, and therefore that somehow shows that they were the more aggrieved or caring spouse. More important than who filed first, who is the petitioner, and who is the respondent, are the timing considerations I mentioned earlier. Notice that timing issues are not exclusive to the petitioner. The respondent could file a status quo order along with their response if they have the facts for it. For more information on the status quo order, take a look at Oregon Revised Statute, ORS 107.138. And for more information on the custody factors, you can check out ORS 107.137. If this article helped you understand the divorce process better, consider our divorce form packages that contain forms to begin and finish your divorce in Oregon. Each form contains a video guided tutorial that you can watch while you fill out the forms. The tutorial explains each entry and also discusses general information about Oregon law, such as how custody is determined, spousal support, property distribution, and more. Each entry also contains written instructions for how to complete the entry. Well, that concludes my discussion on the article, Is It Better If I File for Divorce First in Oregon? I'm Joseph Lavelle, and thank you for following along.